Welcome back. Chapter 4, Civil Liberties. These are the lecture notes. Eternal vigilance is the price of liberty. It's a quote commonly attributed to founding father Thomas Jefferson, but it was actually Irish politician John Philpott Curran. We start with the first section. What are civil liberties? Civil liberties are limitations on government power intended to protect the freedoms that governments may not legally intrude upon. And as a reminder, as we go through these lecture notes, this is what I would normally take 2 75-minute lectures or 3 50-minute lectures to cover. So if it feels like it's being a little bit forced, well, it is. We're trying to do it in one video. However, in the advent of the COVID quarantines and shutdowns, we have limited time in the classroom. So I just wanted to give you what I normally would be holding at the front of the classroom and writing on the board over 150 minutes in a class. So bear with me as I go through my own notes here. So civil liberties are limitations on the government that protect the freedoms of people. And we keep in mind, in our government system, the people are the ones who are technically controlling the power. Now, a lot of times government officials try to send the opposite signal. But what they need to keep in mind is our country was founded on civil liberties. Now, when we say civil liberties, a lot of people want to compare them to civil rights, and those are actually separate from civil liberties. Civil rights, which we'll cover in Chapter 5 in detail, are guarantees that government officials will treat people equally and that decisions will be made on the basis of merit rather than, say, your race, your gender, or other orientation or personal characteristics. The U.S. Constitution, and in particular the first 10 amendments, which is known as the Bill of Rights, protects the freedoms and rights of individuals. If you recall, the anti-federalists were the ones that insisted that the Bill of Rights be included in the Constitution, and furthermore, they became the first 10 amendments of the Constitution. A very quick summary followed by some sections where we'll go into the first 10 amendments in much detail. The First Amendment obviously is the freedom to speech and religion. It's right to assemble and petition the government for redress of grievances. So it assigns citizens the rights to speak out freely, to practice their own religion, and to address grievances that, quite frankly, weren't being addressed by the British prior to the Revolution. The Second Amendment, highly controversial, is the right to keep and bear arms, as well as maintain a well-regulated militia. We'll talk more detail in that here in a second. So the Third Amendment is the right to not house soldiers during times of war. And if you recall in our initial chapters where we were talking about the Declaration of Independence, that was one of the major grievances. The British monarchy were kicking people out of their houses and having soldiers stay in their homes and sometimes just shagging up with them, sleeping in their bedrooms, and you didn't have a choice. That was obviously a grievance they wanted to make sure didn't carry over to our new country, the new United States of America. So they made it the Third Amendment. The Fourth Amendment is the right to be secure from unreasonable search and seizure. There was a lot of that going on during the time of the pre-revolutionary, where British lords were just kind of, lording over people and taking what they wanted and pinning crimes on people, whether or not they were true or not. So that kind of led to the Fifth Amendment, which is the right in criminal cases, including due process. Rights in criminal cases, that is, including due process, and indictment by a grand jury for capital crimes, as well as the right to not testify against oneself. So if you always hear people say, hey, I plead the Fifth, they're trying not to self-incriminate. The part about the grand jury is that is a jury of your peers. So you don't face some sort of tribunal. You face your peers who are called for jury duty. And they hear a case and decide innocence and guilt. The Sixth Amendment is the right for a speedy trial by an impartial jury. So 2 parts there. Your trial should be within a reasonable time frame. That's debatable. Some people says, that's within a week, and some people say, that's within a few months. So there's some back and forth there. An impartial jury is, again, a jury of your peers for the trial, and they shouldn't be, biased one way or the other towards innocence or guilt. Seventh Amendment, again, we're looking here at trials. Only we're looking at civil cases. So you have the right to a jury trial in a civil case. And that's a lot of the jury trials you see in modern days. Those are conflicts between people and businesses, businesses and businesses, and people. So they're not criminal, but they are largely lawsuits seeking payment for damages, things like automobile injuries, workman's comp, unlawful termination, etc. The Eighth Amendment is the right to not face excessive bail, excessive fines, or cruel and unusual punishment. We've really found that excessive bail, they've come up with a sliding scale, and it really is hard to define what is excessive. A little more success with excessive fines. If you have a parking fine, they can't fine you $10,000. That would be an excessive fine under the Eighth Amendment. And then cruel and unusual punishment rules out things like torture. In a lot of places, it's being used to phase out the death penalty. And then certainly the methods of the death penalty. The death penalty has to be, quote unquote, humane. That moves us into the Ninth Amendment, which is the rights retained by people, even if they are not specifically enumerated by the Constitution. So if there's like a gray area, ultimately it goes to the people to determine what to do. So again, the people are the power in this country. Please don't lose that. But people are more empowered when they're informed. So going back to our chapter on civic engagement, you have to be informed, especially about your rights under the Constitution. So the 10th Amendment, 1 through 9 speak towards rights. The 10th Amendment is the first one that speaks towards power. The state's rights to powers is not specifically delegated by the federal government. Basically, anything that's not explicitly in the purview of the federal government, the central power, the states have the right to take on that power. So things that fall in between the government, the federal government. So stuff that they don't cover, states can cover. They have the right to do that and the power to do that. Skipping on down to the 14th Amendment in 1868, which basically was at the end of the Civil Wars. The 14th, 15th, 16th are considered the amendments that ended the Civil War. That amendment, rather, the 14th, gave civil liberties more clarification. Thomas Jefferson did say all men are created equal. And at the time, in 1776, he meant slaves as well. But in order for the Union to remain together, and that gets in the Declaration, easy for me to say, period of time, Southern states were very dependent on slaves, so that kind of got put on the back burner. And here we are almost 100 years later, and finally the slaves are freed. The 15th Amendment gave slaves the right to vote, although women, including female slaves, waited until 1920 to gain the right to vote. We just celebrated the 100-year anniversary of the women's right to vote through women's suffrage. I'm recording this in 2020, and it's 100 years later. It's amazing that it took females that long to get that right. But there was a second provision to the 14th Amendment, doubling back here, that applied a due process clause. That specifically stated that, and I'm quoting here, nor shall any state deprive any person of life, liberty, and everybody says the pursuit of happiness. No, it is property. Any person can pursue life, liberty, and property without the due process of law. That's actually that's a typo. That should say with the due process of law. So you have rights under the laws that must be followed. And we're going to talk a little bit more about that as we start to look at some basic freedoms on the next section. Now, there's something called selective incorporation of different aspects of the Bill of Rights. So selective incorporation is the vocabulary term here. That is carried on today and debated in courts. Sometimes states apply certain Bill of Rights things a certain way and another way, and sometimes not at all. So you've seen over the years a lot of conflicts between that. We'll have some illustrations of that coming on later on in this document. So the second section in the reading is securing basic freedoms. So here we're going to break down the amendments into different categories. The first category is basic freedoms. And the first, obviously, is the First Amendment. And I'll let you read through the amendments, because if I read all these things, man, we're going to be here all day. But essentially, this First Amendment did a couple things. First, it was the separation of church and state. It had an establishment clause, which said that Congress and states cannot establish a national religion. A lot of people that came to the colonies pre-revolution were seeking religious freedom. So this addresses that. In England, the monarchy was the head of the church. So there was a lot of, shall I say, non-desirable connections between the central government, the central power of the monarchy, and how the local religion was rolled out. So there was a lot of persecution there. So people came here for religious freedom. So one of the early requirements of the First Amendment is that federal government in the states cannot establish a national religion. It can't be forced on you. There was also the Free Exercise Clause, which limits the ability of government to control or restrict religious practices. This is something that's highly contentious, but what people don't realize is you hear a lot of people say, hey, we have freedom from religion. Well, you also have freedom of religion. So it runs both ways. The Establishment Clause says, hey, they can't tell you what to practice, and the Free Exercise Clause limits the government control on things like religious practices. So the second part, and obviously the much more ballyhooed portion of the First Amendment, is free speech. So the freedom of expression, 4 distinct rights, including free speech, freedom of the press, freedom to assemble. That's been a hot button topic with the quarantines and shutdowns related to COVID-19. And the freedom to petition. So you can petition for change. You have the right to express your voice even if people disagree with you. Now keep in mind, you have free speech. That just means, hey, someone from the government is not going to put you in prison. But your employer, as you guys enter the world, has the right to terminate you if they deem what you say to be offensive. A lot of people confuse free speech with you can't fire me for if I say what I want to say. That's not true. We can't imprison anyone for saying what they want to say, but your employer can absolutely let you go if what you say is offensive. Moving on to the Second Amendment, this is about the right for people to keep and bear arms and shall not be infringed. That is one of the most quoted passages by the pro-gun folks that you'll ever see. It's one of the most controversial amendments. It's very hotly debated. It's also among the shortest amendments, which might lead to why it is hotly debated. But the words, the right of the people to keep and bear arms shall not be infringed, are pretty stringent. So there's not a whole lot of arguments that can be made, and it's been up in court several times. And local governments, state governments have different rules, and they vary. We live in South Carolina. I'm in South Carolina right now, so very pro Second Amendment states. Whereas you can kind of go to Illinois or even municipalities like Chicago, and they literally ban weapons, at least firearms, and so that's something that's been challenged in the courts, and it really just depends where you live. That selective incorporation that we talked about at the end of the previous page really takes hold. Third Amendment, again, no soldier shall be quartered in your house. Again, that was a direct reflection of a grievance in the Declaration of Independence. Thankfully, not really a hot button issue nowadays. The Fourth Amendment is the right for people to be basically, you can't just search somebody's house. You can't be law enforcement and just search or take something. People have rights to their property. So it sets a boundary between the general individual freedoms and the rights of those suspected of crimes. If we didn't have something like the Fourth Amendment, law enforcement could just say, you know what, I suspect they're doing a crime, I'm going to go take their stuff, or I'm going to go look for something. They can't do that. They have limits on their searches and seizures. They need warrants, and they need probable cause. So a search warrant is a legal document signed by a judge allowing police to search and or seize persons or property. Probable cause is the legal standard for determining whether a search or seizure is constitutional or if a crime has been committed. They both have to go in front of a judge to get ample and show ample evidence to be able to get a search warrant and to establish probable cause. Search and seizure is made illegal. It's subject, if it does occur, an illegal search and seizure. looking for, say, evidence, that's subject to the exclusionary clause. So if something is obtained illegally by law enforcement, by whatever, it's not admissible in court cases. Protected under the Fourth Amendment. Moving to our next category within the amendments, and it's the right of suspects. So we're kind of moving into the criminal genre. If someone's arrested, the rights that they have. Under the Fifth Amendment, again, people claim the Fifth, which allows you to not answer a question because it may incriminate you. Now, it makes you look really, really guilty, but the Fifth Amendment is there to protect you. Actually, if you're also married, you don't have to testify against your spouse. That's another extension of this amendment that comes later. So, with the Fifth Amendment, on a federal level, serious crimes must be prosecuted only after an indictment has been issued by a grand jury. So, again, a jury of your peers. Less serious crimes can be charged without a grand jury, but significant evidence has to be given to a judge. So, on a state level, grand jury is not required. There is selective incorporation of the Bill of Rights here a lot, but a judge is required to hold a preliminary hearing to decide if, based on evidence, a trial is warranted. So say someone's arrested on a state level, maybe low-level felony, misdemeanor, whatever. A judge, so that suspect will be brought in front of a judge, and the prosecutor will present their case, at least their preliminary case, and say, hey, this person we think needs to be held or charged, and the judge will make a decision as to whether or not there's enough information there. That gives another check and balance to protect against the lack of due process. Now, in the armed forces, all bets are off, man. It's a separate process, no grand jury, you have court-martial. It's a whole other thing that we don't really explore in this course. There's a couple of key terms related to the Fifth Amendment. The first one is double jeopardy protection. A suspect cannot be tried twice for the same crime once they've been acquitted. So let's say you're brought in, not you, because you wouldn't be brought in, but so let's say somebody's brought in for murder. O.J. Simpson, right? He was found not guilty. He can't be tried again. He's not guilty. He can't be tried again. Now, he could be pursued in civil court, and the civil courts found him very much responsible for the death of those two people, and he had to pay a bunch of money. But in terms of criminal cases, he cannot be tried twice for the same crime because he's been found innocent once. So that's double jeopardy protection. Self-incrimination. You can't incriminate yourself. Self-incrimination. Why was that so hard to say? You have protection by taking the Fifth. And that means I'm taking the Fifth Amendment right to not self-incriminate myself. So if someone asks you something and you know the answer is going to incriminate yourself, that, yeah, you did whatever this crime is, you perjured, whatever it is, you plead the Fifth, and that cannot be, your testimony will not hurt you because you have the right not to self-incriminate. Miranda Rights. You guys, if you ever watch a police show, you've heard these. You have the right to remain silent. You have the right to attorney, blah, blah, blah. 1966 Supreme Court case. So it started in Arizona, Miranda versus Arizona. It worked its way all the way up to the Supreme Court. Ernesto Miranda was a criminal accused of kidnapping and rape. He was a bad dude. He got arrested. He sat down with the cops, and they were just chatting him up. And he kind of gave some incriminating testimony, more of a confession, but it was in conversation. And he contested that this wasn't a confession during an interrogation because he was just talking. He had no idea that what he said could be used against him in a court of law. So if you that sound familiar, right? Those are in the Miranda Rights. The case went all the way to the Supreme Court where Miranda won. His confession was thrown out, so they couldn't use the confession. But he was subsequently tried and convicted based on the merits of the evidence of the case. So I mean, he did it. There was enough evidence to to take care of it, in trial. But I guess they were wanting the confession just so they could go straight to sentencing. Anyway. Since that case, criminals are now read what's called the Miranda Rights, informing them of the rights to remain silent, right to an attorney, etc. The Fifth Amendment also addresses the right of economic freedom, which can be pitted against state powers like eminent domain claims. So one little clause in the Fifth Amendment says you have the right to pursue your own economic freedom and your own prosperity. And a lot of times, state and local governments will try to claim your property for eminent domain to put it in a highway or something. And people have been successful in evoking the Fifth Amendment under economic freedom. Generally speaking, eminent domain cases don't end well for anyone. It looks bad for local and state governments, and it usually costs a lot for people to fight it legally if your land is being claimed. So it's kind of a catch-22. So if you fight it, you stand a chance, but you're going to run up a big bill trying to fight it. So you would hope that somehow either the state or local government would drop the claim or at least offer significant compensation for your land, let's say. The Sixth Amendment, moving on there. Once someone is charged, and again, we're talking kind of the criminal thing here again. Once someone is charged and indicted, the next stage is the trial itself. So unless a plea is reached, and we can talk about that here in a second, this amendment governs how trials are governed. It's not easy to say. You have the right, again, to a speedy trial. You have the right to a public trial with an impartial jury. Now, if you're guilty of sin and someone offers you a plea bargain, which is an agreement between a defendant and the prosecutor in which the defendant pleads guilty to a charge or a lesser charge in many cases, in exchange for a more lenient punishment than they would get if they were otherwise convicted. Someone might offer a person a plea bargain and they know they're guilty and they take it. You avoid the trial. This amendment also allows for defendants to be a witness in their own defense, so you can testify for yourself again under the Sixth Amendment. While you don't want to incriminate yourself, you can testify in your own defense. Okay, anything the prosecutor asks that would be incriminating, you can plead the Fifth, which is the amendment up here. Finally, this amendment guarantees the right of the accused to have an attorney. So, much like the Miranda Rights are reinforced up here in the Fifth, you have the right to have an attorney, even if you can't afford it. The state will appoint one for you. Now, moving along to the Seventh Amendment. These establish the rights of those engaged in civil disputes. So disagreements between individuals or businesses where people are typically seeking compensation. This is the civil courts. So we've moved from criminal courts to civil actions here. Examples include automobile accidents where injuries occur, wrongful death lawsuits, conflicts between firms, between customers and firms. And because of this provision, all trials in civil cases must take place before a jury unless both sides waive their right to a jury trial, which is kind of unlikely. Judges can determine whether the claims or requests for discovery are factual and necessary or relevant. So pre-trial hearings, there won't be a jury, but as people are making some outlandish claims and you have evidence that it's not true, the case can get thrown out before it even goes to trial on the basis of a judge. Or there can be some claims and there's factual facts to support what the plaintiff is saying. They can send it forth to a trial. Then a jury will be seated for that trial, and the trial will commence in a civil sense. Now, moving on to the Eighth Amendment. 10. We're on 8. All right. Excessive bail shall not be required. So bail, as determined by a judge, that is excessive is prohibited. Now, here's the thing. Define excessive. They pretty much have a sliding scale for pretty much every criminal action, but rarely does it get declared that bail is excessive. But what is bail? Bail is paid in lieu of being held basically in prison for trial. Largely, people can't afford just to pay the whole bail, so the bail bond servants, you can see these shows and talking about bail bondsmen, those guys usually pay up to 90% with defendants paying 10%. So if you were held, let's say, at $1 million bail, you could sign a deal with a bond servant that they would pay $900,000 of it with added and interest, and you would put down $100,000 to be able to get out of jail while you await trial. Now, all monies are forfeit if the defendant does not show up for trial. And this is what you see in like the bond servant shows where people jump bail. And in that example I gave, the bond servant is out $900,000 unless they go find the fugitive and bring them to justice. So that's why you see those shows. That's why they're so interesting. So it is rare that bail is successfully deemed excessive in this country. This amendment, the Eighth Amendment, also bans cruel and unusual punishment. Things like torture and cruel death penalty methods. We used to do some jacked up ways to implement the death penalty. Things like being drawn and quartered your arms being cut off, your legs being cut off, and then your entrails being pulled out. That's pretty cruel and unusual. So the death penalty methods have evolved over time. Electric chair hangings, firing squad, to now largely, gas chambers, largely lethal injection in the states that still have a death penalty. So, part 4, interpreting the Bill of Rights. This falls largely on the 9th and 10th Amendments. So, the Bill of Rights 1 through 8 are largely interpreted by things in the 9th and 10th. So, the 9th Amendment makes clear that, look, at the end of the day, the rights are retained by the people. It's not the government. I sure wish some people up in Washington, D.C. would read this one again. Because the Constitution is not 100% exhaustive in every situation, the people, through lawmaking, changing, trials, etc., determine what the right thing is and how the Constitution should be interpreted. Disagreements naturally arise, which is where the court systems, all the way up to Supreme Court, intervenes. Okay, so at the end of the day, if it's unclear, let the people decide. That's what the 9th Amendment says. The 10th Amendment is focused on the power but not rights. So just like we said before, the first 9 amendments are about rights. The 10th Amendment is about power. And it's basically saying, hey, states, you're delegated the powers not allocated to the federal government. So everything in between, states can step up and take care of. Certainly, states sometimes have overreached on their power and been put in their place by the federal government. That's kind of what the system we've leaned towards post-Civil War. But the states have the right to allocate your rights and liberties. They have the power to allocate your rights and liberties more fully or extensively than the federal government does. So you saw this a lot in the civil rights era, where you would have civil rights passed by the federal government, and then states would either really enforce it, kind of enforce it, or not enforce it at all. And you saw these conflicts between states and federal powers, where the military, the National Guard was called in to integrate schools, for example, in certain states. In certain states, it went really well. There was some integration with dignity in a lot of places, which unfortunately doesn't always get a lot of attention, but it takes a few bad apples, man. But states have the power to make sure people's civil rights, which we'll talk a little bit more about next week, and liberties are being ensured. Now, really quickly, at the opening of this chapter, you actually see a picture of Edward Snowden. And you're like, what's that about? Well, the Patriot Act, and again, I'm a bit of a policy honk, so if something's called the Patriot Act, the chances are a real patriot would hate it. But the Patriot Act was passed through because of some fear of the unknown that came out of the post-September 11th attacks. And it has many advocates of personal liberties alarmed, as government agencies such as the National Security Agency, NSA. I got my smartphone right here. They're probably listening to me right now. What's up, NSA? How you doing? I'm recording a podcast, or not a podcast. I'm recording a lecture. I might record a podcast later about how you guys are spying on us. So the NSA can spy on a citizen's calls, text messages, emails, etc. without due process. Edward Snowden, a former government contractor, leaked thousands of classified documents to journalists in June 2013. Snowden was found guilty of espionage and currently lives in exile in Russia. He just bolted the country. He got the heck up out of here. Should he return home, he would be immediately arrested for his actions and basically spend life in prison. This incident is hotly debated, and the program Snowden leak was found to be illegal in August of 2020. The court systems came out and said, yeah, that's not constitutional, dude. You can't be doing that. Yet, Snowden remains a fugitive living abroad. If he came home, he'd be arrested, and the courts have already said what he exposed is illegal, but his crime is how he exposed it. So there's a lot of debate there. Some people say, well, hey, he's a criminal. He should be forced to live in Russia. He's living in Moscow. Some people say, you know what, he exposed something that they were spying on us. This guy's a hero. Bring him home and throw him a parade. So this is something to keep an eye on over the next few years just to see how it shakes out. So I hope you found this helpful. It was a breakdown of the Bill of Rights and how they affect your civil liberties. Now, you guys are a little bit smarter. You're a little more informed. You're becoming what I call a politician's worst nightmare, an informed citizen voter. You have to be informed to make sure your civil liberties do not become eroded. Thank you for listening to this lecture. Hope you're having a great day.